our guest, you all know her, Julie Kelly, with us now. Check out Declassified. You can subscribe to that on Substack. That is Julie's publication there. It is excellent. I read it. Clay reads it. Julie, thanks for being here with us. I wanted to just jump into this. A lot of legal action going on today. Big Supreme Court case heard, going right to the heart of presidential immunity, the J6 case against Trump. Here is the headline from the New York Times. Wanted to have your reaction to it after hearing oral arguments this morning. Conservative majority seems ready to limit election case against Trump. Julie, I feel like I'm surprised that I'm going to have to say this, but from the New York Times lips to Trump's ear, to God's ears. What do you think?
Well, I think that they are probably right, and here's why. Because the big debate centered around official acts as president versus personal or even private acts. And there was a lot of discussion back and forth as to what represents an official act, what doesn't. And of course, that creates a whole slippery slope, which several of the justices, at least Kavanaugh, Gorsuch, Alito, had indicated serious concerns about. Who then becomes the referee as to what's official or a core function versus political, personal, private. And so going back to the indictment, and I really need to underscore this, Clay, Buck, we're talking about 4 counts. Okay, they talked a lot about murder. They talked about bribery, about initiating a coup, killing people. That is not what this indictment is about. It's really important for people to be reminded we're talking about 4 of the most vague statutes on the books, 2 of which we talked about last week and the Supreme Court addressed. 1512C2, obstruction of an official proceeding, extremely vague, and then 2 very vague conspiracy statutes. So these are not clear-cut laws, crimes, murder, bribery, drug trafficking, the things that we would expect a president to face criminal prosecution for. So in the indictment, there are certainly elements that are completely within the president's purview, such as replacing an acting attorney general with somebody else, which is what he considered replacing Jeffrey Rosen with Jeffrey Clark. There are other things that fall under official acts. Things get a little murkier. Even John Sauer, who is representing Donald Trump, admitted that, using private attorneys, calling up political parties or officials, to conceive or encourage them to come up with alternative slates of electors, that might fall under personal/political. So I think that that's what the New York Times and others are hinting at, is that the indictment itself could have to be narrowed down, determining whether it's Jack Smith or this gets kicked back to Judge Tommy Chutkin, who was the one who originated the order denying immunity. And then she has to figure out official versus personal, hold some sort of evidentiary hearing to determine what falls under official, what falls under personal or private.
My biggest takeaway for the particulars of the timing here, Julie, is that there's virtually no chance now that any case other than the case that is currently proceeding in New York City is going to be decided before November 5th. That is a jury ruling. Based on the arguments today, and there are a lot more issues at scope than just Trump, and we'll maybe get to that with you in a sec, but would you agree with me that it's Alvin Bragg and then it's to the voters in terms of lawfare and what's going to be complete?
I do. We still obviously have the Southern Florida case prodding along, and there is a slim possibility that could go to trial before the election. But look, Clay, to your question, if the Supreme Court kicks this back to the district court, to Judge Chutkin, and says you need to hold these hearings to figure out what falls where, they also will have some choice words for the circuit court. I don't know if you guys caught that. Chief Justice John Roberts, not pleased with that 3-judge panel's decision, calling it tautological, basically circular reasoning that they used to uphold Judge Chutkin's ruling. So if they kick that back, Clay, let's say they do wait until the end of June or even the end of May to come back.
Sorry to cut you off, by the way. I wouldn't be stunned if they put this ruling come out on July 3rd, the day before the July 4th holiday, just to kind of bury it into that. Sorry to cut you off. I was looking at the calendar. That's
Right.
it's the last case they're basically hearing. That could be a possibility if they wanted to hold it as long as possible.
True. That the end of their term is June, but to your point, Clay, they can issue orders, I believe, after that. So let's say that they do. It kicks back to Chutkin, after 4th of July week is over, and she immediately orders we're going to hold an evidentiary hearing 2-3 weeks after that. You have to file your motions, responses, et cetera. They really start to run out of time. But I'm going to posit something even more terrifying than what we've talked about is going to trial in J6 before the election, is putting Donald Trump on trial after the election. Just imagine for a moment that they have the evidentiary hearings. Chutkin decides, okay, this part of the indictment, these acts are official, these aren't. It gets, runs the gamut. And then they toss it back. Okay, this is settled. He can go on trial for private personal acts, and here are the ones that we determined. Then can you go to trial the end of November, December, early January, even if Trump wins, especially if he wins? That's another nightmare scenario that could be created by.
But he would be able
here.
to pardon himself then in that case if he won, even if he potentially got convicted. But you're right. I mean, this is honestly, I don't know why we still do this. I don't know why we have such a long period. What you're hitting at, Julie, November 5th until January, I'm not sure, 20th or whatever the
20th.
date is when the official,
20th.
yeah. I mean, that's a long time for a defeated president to remain in office. Historically, it used to not be till March, but that was because you had to travel long distances.
It's also time, they have a transition that they're trying to prepare for. And, I think it's meant to ease the situation. And they didn't prepare for 4, now going on really 5 criminal indictments against one of the candidates to be a part of the
but I mean, I think
situation.
that like kind of abeyance area there is kind of a mess.
Julie, can I ask
out.
you about, this is another one of these things. It's kind of buried today. It's a big deal on any other day, but the Supreme Court arguments about whether the president could order a coup and effectively undo the constitutional order or not, et cetera, are pretty interesting. But 11 of the electors have been indicted in Arizona. The Arizona AG put out a video today. Chris Mays. What do you make of this? Like, they didn't indict Trump, they indicted Mark Meadows, and it seems to be somewhat in parallel to or somewhat similar to the Georgia case, at least in terms of some of the conduct. What do you make of all this?
I mean, look, I tweeted this last night, and I hate to say it. You have to envy how Democrats understand how to coordinate, conspire, and leverage their political power. Here's a guy who probably really didn't, or a woman who really probably didn't even really win the Arizona Attorney General's race. But it doesn't matter, because as soon as they take office, they leverage and weaponize their power against their political foes. I haven't had a time to go through the whole indictment, just getting ready for today. But, this is Georgia, this is Michigan, this is all to bolster the idea. But even though Trump is unindicted co-conspirator, it is to bolster what's happening here in this J6 federal case. And it's also a signal, and we heard a little bit about this today. Amy Coney Barrett really is disappointing. But to continue to raise the idea that asking for or having others create alternative electoral certificates is a crime, which it hasn't. The National Archivist told Congress, we get fake electoral or manufactured, made up alternative electoral certificates every presidential election. This is not new. So to criminalize it is also to warn people, if you protest in any way, the 2024 election, whatever happens, whatever stunts you want to pull, whatever you want to do to demonstrate against, let's say Joe Biden gets reelected, we are going to use our lawfare against you. And there's nothing to stop them. So this is really to, I think, add more optics, bolster the political and public view that there's something really criminal about concocting or pretending that you're, sending in an alternative electoral certificate. Just ridiculous, but so, again, such a dangerous descent where we are headed using this lawfare, not just federally, but state power too.
Julie, last question for you. You mentioned South Florida. You've been covering that case. Judge Eileen Cannon has allowed a large amount of previously censored materials to be allowed to be displayed publicly. What should we know that is significant about what that has uncovered?
We should know, and I want to give kudos again to Judge Cannon. I know we've talked a lot about her, but it reveals, and this is why Jack Smith wanted all of this concealed, it reveals Joe Biden's White House, including some of his top attorneys in his general counsel's office, working collaboratively with the DOJ and archives to manufacture a records/documents case against Donald Trump. This completely flies in the face of what Jack Smith has alleged in his indictment there, but also what we've been told that Joe Biden and his White House is completely hands off from this prosecution. So they were deeply involved, same players, DOJ, FBI, the archives, the intelligence community. This is like getting the Russiagate, FISAgate band back together. So kudos to her. There's going to be more unsealings today. I will be posting later, Julie_Kelly 2, which is the grand jury transcript of Waltine Nauta, Trump's close personal aide, also who has been charged in that case as well.
Julie Kelly,
The
everybody.
grand jury, we should mention, by the way, Buck, that took place in Washington, D.C., before they then flipped the proceeding all the way down to South Florida,
Yes.
so that Judge Cannon wasn't in charge of this.
Substack, you can also subscribe. Julie, real quick before I let you go, I know Clay said last question, but I'm throwing in a last question because I'm really curious.
Right.
What do you think the biggest legal risk for Trump is now of all of the cases and scenarios?
I mean, right now, I have to think what's happening in New York. Unfortunately,
I
I
thought
don't
you
think
might
many
say
people
that because
predict
Clay and I were
Yeah.
just talking about that. This actually, I think, what we see happening puts more pressure on them to get even crazier in New York City, where they just have full control and there's really no oversight. Go check out Julie's Substack, everybody, Declassified. Julie, always appreciate you being with us.
Thanks, guys. Have a good day.
Look, despite everything the Fed has been trying, we are still feeling the effects of inflation. Whether you're filling up your car, grocery shopping, making home repairs, everything is more expensive. And most of the time, we use a credit card to pay these bills. Credit card debt is at an all-time high. If you're a homeowner, there's a way out. Call our friends at American Financing. They can put together a plan to pay off that high-interest credit card debt and create meaningful savings for you every month. They're saving people just like you an average of $854 a month and closing in as fast as 10 days. Call their salary-based mortgage consultants today. It costs nothing to get started. And if you start today, you couldn't delay 2 mortgage payments, giving you greater savings up front. Dial American Financing at 800-777-8109. That's 800-777-8109 or visit AmericanFinancing.net. That's AmericanFinancing.net, NMLS 1823334, NMLSConsumerAccess.org.